The hearing is in the matter of TCD 009-2020 before Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Raidarus Advocates and Legal Consultants. Lead counsel is Martin Kushdell. The defendant is represented by Charles Russell Speechlys LLP. Lead counsel is Thanos Karvelis.
Yes, Mr. Karvelis, it's your application, I think.
Morning, Your Honor.
Morning.
May I also introduce my associate, Mr. Glenn Bull, is also in attendance, and he may assist with documents if are necessary to be projected.
Yes, thank you.
May I please ask, Your Honor, if you had the opportunity to read the application, the skeleton arguments, and the witness statements exchanged?
Yes, I have. Yes.
Thank you very much.
I've read the witness statements, but not necessarily all the attachments.
I understand. Thank you very much. This is helpful. If I may start with a little bit of housekeeping, I think we have through matters at hand to deal in this hearing today. We have obviously the application for security for costs and the application under the practice direction number 5, which were made by the defendant, Reem, and I think today we will have also the case management,
Yes.
the case monitoring hearing. I would propose, with your permission, that we deal with each matter separately. Start with the application for security for costs, and then move on to the application under practice direction number 5, and then leave the case monitoring progress last.
Yes. Very well.
Thank you. Thank you. Since you had the opportunity to read the skeleton arguments and the witness statements, I do not propose that I simply, repeat our skeleton arguments. I would rather address some of the points made by my friend in their skeleton arguments. Before that, and I wonder, although I'm sure that you are now much more familiarized with this case, I wonder if it would be useful to give you to put a context of where we are. What is this matter about?
Yes, you can take it. I've reminded myself of the history of the previous action and then the joinder of the new action to your counterclaim, in effect. But take it briefly.
Yes, I will very briefly. And I will not use the terms, I know it's not very common, but I will not use the terms claimant or defendant or counterclaimant because it gets a little bit confused. With your permission, I will use the names of the parties. Yep. The dispute commenced before the IFC courts with a claim filed by 5 against Reem. Reem followed with a counterclaim. 5 requested at the beginning approximately 7 million dirhams. Reem filed a counterclaim for approximately 17 million dirhams, and subsequently 5's original claim was struck out by order of Justice Field. And subsequently, in August this year, 5 made a fresh claim, which was previously a bit more than 17 million. Now it has been reduced to approximately 11 or 13 million. The original set of 5's claim and Reem's counterclaim is TCD9, under case TCD9, and 5's new claim, it is under TCD3. And both cases are now merged, are consolidated. Our application for security for costs is made by reference to TCD3, i.e. the second claim of 5. So this is roughly the procedural background.
Yeah.
I looked at the two witness statements made by 5 as well as the skeleton arguments of my friend, and it strikes me that the only defense offered by 5 in this application is simply that it is late. This is the only sensible defense made by 5. As I'm sure your honor is fully aware, Rule 25 of the RDC has very specific requirements, certain conditions that need to be satisfied. It is the claimants in this application, it is Reem's view that we have satisfied these requirements of especially Rule 25, paragraph 102, and we will be happy to address any question that no doubt and any issue will arise. But importantly, the only defense offered by 5 is that the application for security of costs was not made prior to the case management conference, i.e. 5 relies on Rule 25, paragraph 107. If I may take you to 25-107, the language which is carefully selected by the legislator, that is my view, is that first applications for security should not be made later than at the case management conference and should not be left until close to the trial date. And delay to the prejudice of the other party or the administration or of justice will probably cause. I submit to you that the legislator chose the words carefully. There is no doubt that ideally, the optimum is that any such applications are to be dealt with as early as possible prior to the case management conference, but the legislator did anticipate that there are circumstances where it is justified, there are instances where it is justified under the circumstances that the application is made relatively late. And we submit that these circumstances are entirely justified. On this, and it might be helpful, I have prepared the chronology of events during the critical period, which, with your permission, I would like to share on screen. I think it would help your honor and everyone understanding where we are. May I?
Unless there's any objection.
I just don't know if I've seen this document or what's about to be produced. I just wonder if my learned friend can clarify.
It is not a document that we shared. It is simply a table which summarizes the events over the critical period of time. I can walk through. I can narrate the events, but I think it will be for the benefit of everyone, including my friend. if it is on screen.
Well, I would say ordinarily, even if my learned friend were to orally dictate what happened, then that would be permissible anyway. So I can't sensibly object, but I would like it noted that I haven't seen it. So if there's anything in there that I would need to take instructions on, then I would need to obviously see what happens. But
I'll tell you what, while this is being done, could Mr. Carvelis' assistant email you a copy of the document? And that might then enable you to get it at some stage before you have to speak.
Yes, and as long as he could CC my Mr. Hashim Al-Adros as well, who's assisting me, that would be very helpful.
Can that be done, Mr. Carvelis?
Yeah, I'm sure it can. I'm sure it can. Mr. Bull, please do share it with our friends.
Yeah, thank you very much. So if you'd like to.
While waiting, the background here starts in of what I will try to explain starts in July 7th, beginning of July last year, 2021. On 7th of July, the defendant Reem filed an application.
Are you going to put the thing on screen?
Yes, I guess we are. Mr. Bull? Yes, this is it. If we can make it a bit bigger, because it's very difficult to read, at least in my screen. On my screen. Glenn, can you hear me? Yes. A bit more, please. A bit more. A bit bigger, please. Don't be shy. A bit more.
That's better.
Yes. Okay. Thank you. Yes, this is. No, that's.
That's it.
Yes, I think it's here. I think it's here. You may need to scroll to the right, perhaps to as necessary. On 7th of July 2021, the defendant filed an application, Reem filed an application seeking default judgment on part of its claim, which is, we call it default application, default judgment application number 6. And there was a hearing listed for this application, which was the 27th of October 2021. This was a heavy application. Approximately 2 months after, on 8th of September, the claimant filed a notice to appeal the decision of Justice Field, which was made on 31st May, which the second permission application for Your Honor, the 31st May 2021 decision of Justice Field was the one which rejected Five's application to strike out Reem's claim.
Yes, I remember.
Under TCD 9. You may recall that the claimant relied on RDC 44.30 to file the application without any grounds. Claiming it was impractical to comply with Rule 24/29 and therefore required 21 additional days. Following that, and on 22nd of September, you will see, I don't propose that I take you through every single step. We have color-coded this document. Green are the actions that are in relation to TCD 9, and yellow are in relation to TCD 3.
Yeah.
I would be happy to take through each one of these steps. What I'm trying to highlight, and if we can scroll down, that the period leading to the case management conference, which Your Honor may recall that it was scheduled and actually took place on 17th of November. It was a very congested, very congested period with a lot of actions. Now, some important dates which we will see later on in this chronology are the 11th of October, where the defendant, the 23rd of September, where the claimant 5 filed the particulars of claim in their new claim, TCD3. And then if we scroll down, we will see that 5 filed their reply to defense on 31st of October. If we can scroll down, why I say this is that during all this congested period of time, the very first time that Reem was aware of the circumstances surrounding 5 Real Estate Development LLC, i.e. the claimant in TCD 3, and whether it had or did not have any assets or any means to satisfy any awards against it, was first established in September and finally and definitely concluded at the end of October, i.e. 2 weeks prior to the case management conference. This is when we knew. You will note, Your Honor, that the reply to defense, and it should read the claimant, not the defendant, filed its reply to defense on 31st of October, and the registrar advised the parties that the case management conference was listed for 17th of November, the very next day. Therefore, if we want to talk about any delay, we are looking at this 17 days between 31st of October and 1st of November. 31st of October and 17th of November, i.e. when it was entirely clear to Reem the circumstances surrounding its counterparty, 5, and the period between the case management conference. Now, the parties, you will see in this chronology that on 27th of October, the schedule for the default judgment application number 6 was listed, i.e. 3 days before. This default judgment application, which resulted in consent orders by virtue of which 5 made a payment of 1.9 million dirhams to the court, where the consent orders were agreed and filed only 2 days before the hearing, on the 25th of October. All the way until that period, the parties, on top of any other issue that had to be dealt with in these proceedings, including the defense by Reem to the new claim of 5, or the reply of 5, the reply to defense of 5, were running all these in parallel. So it was a very congested, an extremely congested period of time.
Yeah.
The parties, and I am sure my friend will correct me if I'm wrong, but I believe on the initiative of Reem, agreed to consolidate these two cases, TCD9 and TCD3.
When was that?
The consolidation was on, if you give me a moment, Your Honor, it's so much have happened. They were consolidated at the case management conference of 17th of November. There was an exchange between the parties, and we, at the case management conference, we agreed to consolidate and ask the judge to issue orders consolidating these two cases, and this was agreed informally between counsels for both sides, as I'm sure my friend will confirm.
Can you just
Now,
help me? Can you just help me? I was reading some of the orders yesterday, and I think I noted that the case management conference was scheduled for TCD 9, and it was in the course of that parties agreed that TCD 3 should be consolidated.
Yes,
so
indeed.
There wasn't a case management conference fixed for TCD 3; it was fixed for TCD 9, and then
Correct.
Then 3 came in.
And it was 3 came in, and it was on our insistence.
Yeah. All right.
If I can take you to Kumar witness statement 1, which is paragraph F53 of the bundle.
Hang on. Yep, paragraph.
This is the 10. Paragraph 10.
Yep.
You will see that if what Mr. Kumar is saying, that the defendant's application is the application for security for cost has been made after the CMC, which was listed on 17th of November, and this, in their view, falls foul of RDC 25.107. If you go to the start of the fourth sentence, in fact, I understand that the defendant's counsel did not make any mention of an application for security for cost of the CMC. We'll come to that. Nor sought an adjournment of the CMC to make such application. This is the crux of the issue. The reason I try to explain all this is the following. The case commenced, the overall dispute commenced in October 2020. We are in April 22. The case management conference for the main dispute was only held more than a year after the case was commenced, and we will not have a hearing until June, 18 months after the claim commenced. The defendant's main concern was at the time that there is nothing that can delay the case management conference any further. That was our own preoccupation. On top of that, and as I said, and although there have been exchanges of witness statements, pleadings by the parties on various occasions for almost a year, more than a year actually, the very first time that Reem was aware that 5 has no assets 5 has no business. 5 has no standing other than being the defendant in claims against 5 Group in this for this project. It was only became clear and in September and later on, late this, October 2021. Before that, we did not know. When and it is telling, when Reem filed its counterclaim, which is now the main item in TCD3 back in February 2021, and 5 responded to this. They did not mention. The counterclaim was made and was expressly mentioned. Our understanding at the time that 5 was the owner of the assets, the owner of the hotel was built. This was not corrected at the time by 5. Despite several submissions made, both in the context of the defense against our counterclaim and in various applications that followed. Mm-hmm. We were led to believe that this was the case, and this continued until first in September, and the late third part of September 2021, and conclusively when they filed their reply to defense to TCD3 now in late October. So I submit that we were not late. At the end of the day, as you pointed out, Your Honor, at the time, there was no CMC listed for TCD3. If we wanted to delay the process, and we are defendants in TCD3, we could do what 5 did consistently and persistently for TCD9. We could have played for time, could have delayed the case management conference for TCD3. We would not have asked for the joinder of TCD3 with TCD9. Let the time work for us, make the application for security of costs, delay as much as we can the progress of TCD3, satisfy ourselves with TCD9, have a judgment perhaps in TCD9, and then see what will happen with this TCD3. We did not opt for this, but because this would not be efficient, it would not serve justice. At the end of the day, although the matters at hand for TCD, for the 2 cases TCD9 and TCD3 are distinct, the factual background is the same. It is the same contract, and to an extent, the same evidence, factual evidence. At least, we thought that the right, the efficient, the proper thing to do was to consolidate these 2 cases. So we are being criticized by my friend, because we acted efficiently without trying to delay the matters further, and then and because in an effort to avoid any further delays and in circumstances absolutely justifiable, we made the application for security for costs a few days after the case management conference.
Yep.
Because this is the criticism. And to cover the last point here. Yes, we did not mention anything during the case management conference. Simply that if we did, it would be seen for sensation purposes only. It wouldn't serve any other purpose rather than making a grand statement. I would like to go back with your permission, because at the end of the day, this application is made and is governed by specific rules.
Yep.
And see if the rules are satisfied. If I can take you back to 25.107 of the rules.
Yeah.
A consideration is for the judge is whether such delay is to the prejudice of the other party or the administrator or the administration of justice. So it is not enough that an application is made later than at the case management conference. Such delay must be prejudicial to the other party or the administration of justice. I submit to you, and any use of the application, and it is discouraged if any use of the application is to harass the other party. I submit to you that not only there is no evidence, any sensible argument made that there was any prejudice to Five, let alone the administration of justice. There is plenty of evidence to the opposite, actually. The hearing for this application could have been done a month ago. The only reason that we do this application today, the hearing of this application today, is because my friend stated that they were not available until 29th of March. When the registrar first requested availability for a hearing for this case, my friend...
When was that?
Let me look at the chronology again. If you can give me a moment, I think I mentioned it in the skeleton arguments. I can't remember the dates by heart. It is in paragraph 32.12 of our skeleton arguments, and I'm sure it is. Yes,
32.12.
paragraph 32.12, yes, indeed. And I'm sure it is in the witness statement.
Yeah, don't worry, I'll find it in your skeleton.
Yeah. So if you, the registrar requested our availability on 15th of February.
Right, yeah.
We advised that we weren't available before the 6th of March, and anyway, it takes at least 2 days, 2 weeks to arrange the hearing, especially of a heavy application. And we were not available 2 weeks between 24th of March and 6th April. All other dates, including 21st of March, and it is the 21st of March is important date. We confirmed our availability. My friend responded that they were unavailable on any date before 29th of March. Your Honor, you will recall that on 21st of March, which is 2-3 weeks ago, we had a hearing about this case for an urgent application made by Five, by my friend. For their urgent application, they were more than available on the 21st of March. For this application, they were not available until after the 29th of March. And the first available date was obviously the 13th of April. So, notwithstanding that we gave the opportunity, we amended, we added evidence to our application, and thus gave the opportunity to my friend to make a second witness statement, which caused a few days of delay to the hearing. Notwithstanding all of that, the reality is that we could have the hearing a month ago.
Yeah.
It was not the Reem's unavailability that prevented the hearing. So, as if this was not enough, the last part of this hearing will be the case progress monitoring, if you recall. The parties exchanged the progress monitoring information, so filed the progress monitoring information sheet earlier this week. And they both confirmed that the case, the combined case, the consolidated case, TCD3 and TCD9, progress without any issues or delays. The only delay is a last-minute request by my friend for a short extension of the time for the submission of expert reports due to illness of their expert, to which we consented, obviously. We had a disclosure exercise which included an application, an urgent application made by 5, which did not prevent or delay the process, especially the trial, any further. Respectfully, I cannot see any prejudice or harm or harassment or anything else as a result of our application for security of costs. And therefore, I fail to see, respectfully, how 25.107 can be relevant in any way. Admitting that, yes, the languages should not be made later than the case management conference. It could not. This is the Reem's position in this. In the circumstances, it could not. It could not without risking a further delay to the main case, to the trial, at the end of the day. And in the circumstances, there is no doubt that there is no prejudice to the other party. The administration of justice was not affected whatsoever, in any way whatsoever, and it is not a case of harassment of the other party. This is, as I said, the only defense made in reality by my friend. I would propose, unless obviously, Your Honor, you have any particular issue that you would like to raise to ask about this, to the other conditions of Rule 25. And I will take you
to.
Excuse me?
That 25.102.
Correct.
Yeah.
Indeed.
And I think you rely
I will
upon
not go
2, 4, and 6. But your real point is 2, I think.
The main point is 2 indeed. Yes.
Yeah.
Although 6 cannot be underplayed.
Yeah.
But 2 and 4 and 6, I think they are together. They are one in this particular case. Let's talk about 2. We argue that there is reason to believe that 5 will be unable to pay the defendant's costs. Let's see what are the factual circumstances. 5 admitted, and it's the only way for us to know, and I will explain why I say it is the only way for us to know, that they are not the owners of the hotel. They are not the owners of any of this particular hotel. Another entity, related entity, parent entity, is the owner of the hotel, but not the litigant on behalf of 5 Group in this dispute. This is their own admittance. What we know is, based on the evidence provided by 5 itself, that they have no bank accounts, and they have, or at the very least, based on the evidence that they provided, again, they have 0 balance in their bank accounts. May I please take your honor to, for example, let's paragraph P13 in the bundle.
Paragraph what?
P, Papa, 13.
Yeah.
This is a statement of account disclosed by the defendant, by 5, by the way, in Bank of Baroda. You will see that in 4 June 2028, on 4 June 2028, they had a 0 balance. Yes, already since 2018, they had 0 balance.
Yeah.
This is the evidence. This is their evidence. Now, I am sure you are familiar with UAE and the way and the access of information available to third parties in the UAE. No one can ask for information unless they are voluntarily produced. So we have a case here that the evidence produced by 5 is that they're not the owners, they don't have any assets, they don't even have bank accounts. They don't have balances, to be precise, in their bank accounts. And they have an application for security for costs against them, which argues that they have no business, any business whatsoever, and no assets at all. I would expect when they sent their witness statement, I looked at Kumar 1 witness statement, the witness statement that they made in defense of the application for security for costs, 28th of December 21, and I was trying to find, I read it again and again, trying to find any passage that refutes this argument. There's nothing. I looked at the second witness statement made by Mr. Kumar on 7th of February. Again, nothing. They are in defense of an application and the core of the application is that they have no assets, they have no means of paying their debts, and the only payments made were to satisfy their own interests and not genuine payments, and there is no evidence mentioned whatsoever offered, any reference offered, any justification, anything that can be used to argue that they are a solvent operating entity with substance. Even more surprisingly, and in my view, absolutely telling, is the skeleton arguments of my friend. If I can take you to paragraph 27 of my friend's skeleton arguments. You will find them if you don't have them at hand, at D33.
Paragraph what? 27.
27.
Yeah.
You will read here. As noted above, the court will need to assess the circumstances of the case. The claimant is a trading company and is forecast to continue trading long into the future. This is now the only language used which implies that they are something more than an empty shell. Conveniently, Your Honor, and with all due respect to my friend, because they don't need to make a statement of truth for the skeleton arguments. The witness statements, which include the statement of truth, have nothing. Nothing, not even this simple insufficient language doesn't say anything. But at least they're trying to say something. It's not even included in the witness statements. And there must be a reason for that. My colleagues, my friends are very experienced. They wouldn't do a mistake like this. I submit to you that it is not in the witness statements because the witness statements have a closing paragraph. My friend tried at length to argue the burden of proof angle. We have the burden of proof, which is respectfully self-evident. Obviously, the applicant has the burden of proof. Claimant, the applicant, has the burden of proof. But let's see what is this proof and how this level of proof, this burden of proof can be satisfied. And we used evidence produced by our opponent, their own evidence, which supports our argument, and the lack of evidence, which in itself, it is also the very strong inferences that could, and in our view, must be drawn from this. Last but not least, the second line of defense, which is paragraph 30 of my friend's witness statement, is that they have behaved properly and they have made payments when requested. Correct? You can see this, I assume, Your Honor.
Yes.
And they mentioned 3 payments that they have made. 125,000 in respect of application number 6. If the judge, if Your Honor will recall, in the chronology that we showed, the very first one, the default judgment application made by Reem for the 1.9 million, the part of Reem's claim which has been recognized, acknowledged by 5. So these are the costs of this application. There are another 27,000 dirhams, which is what? 4,000 pounds, 5,000 pounds, pound sterling, something more than 5,000 sterling, pound sterling. Following as directed by Justice Field, and the 1.9 million, which was the subject of our default judgment application number 6, and which, in an effort to avoid, which the 5 agreed to consent orders, the default judgment application was for payment to Reem of this 1.9 million, and they agreed to pay this because it was paid to the court. They agreed to this because it was payment into the court.
Yeah.
The alternative would be to allow it to go all the way and have an order for payment to Reem. Presumably, they wouldn't be very comfortable with Reem using this money to finance the litigation further. So, the lesser evil for 5 in the circumstances was to at least pay it into the court. And because they had to agree to a consent order to avoid payment to Reem, and payment, so that payment is made into the court, they have to concede payment of the costs, which is the 125,000 dirhams.
Yeah.
So, in reality, the 3 payments they made for their own interest, to avoid what is in their perception something worse. In every other instance, they have not. And not just that, and not just previously. When on 21st of March we had the hearing for their application, Your Lordship issued an order on costs, 110,000 dirhams. It is the 13th of April that was issued on 21st of March.
What is
Payment was supposed to...
What is the usual period for payment?
For 14 days. 14 days. 1/4.
Yeah.
I.e. 4th of April, 28th March is 7 days, 4th of April was 14 days. Today is the 13th of April. They haven't, this payment was not made, and it was an order. In order to delay, as an excuse for the lack of payment, on 6th of April, i.e. after the 14 days deadline, 5, through their counsel, proposed a set-off.
Proposed what?
A set-off.
Yeah.
A set-off. Late. They were already late. They proposed a set-off. Let's see the set-off now. And this is evidence. I was very reluctant, and I had this discussion whether we should make reference to this email from my friend, because it's lawyer to lawyer email, but they added it to the bundle, not me. So they were happy to make reference to it. Can I ask Mr. Bull, because I can't remember right now, what is the number of this exhibit? Mr. Bull?
It's P50.
Excuse me?
50?
Which letter?
P50. P for Papa.
Ah, okay. P50. If I can take your honor, can take you to P50. This is an email from my friend to me.
Yeah.
It makes reference. The second paragraph makes reference to the first line of the second paragraph, to your order.
Yeah.
You may recall, Your Honor, that previously we made an application to amend our,
Yes.
our counterclaim, which was granted. I think it was your order, because
Yes.
I think it was you that granted the order. And as expected, you ordered costs for the application and for the amendment of the defense in favor of 5, as one would expect at the end of the day.
Yeah.
Right? This was not assessed or anything disclosed or the value at the time. I do not want to go into what I don't like very much as a matter of principle, go into the details of the how this 286,000 are comprised. It suffices to say that for 3 pages of an amendment, and we consider it is three pages, the amendment to the defense, because it is marked up, it is 3 pages. They made it in 14 days. They filed this amendment 14 days after they were required to do it in time, and it took them 14 days of work, 7 hours per day by a partner, to come up with a number of 286,000. For the volume of work is approximately £200 per word, calculating the actual work done. They charged at approximately £200 sterling for word. But and surprisingly, and again, it's not my calculations, it's my friend's calculations. Of the overall cost, 25,000 is the cost of the application, and 240,000 is the cost of the amendment of their defense. Again, 3 pages. I'm happy to go through it and look at the markup if necessary, word by word.
Where do I find it?
It is in amended particulars, amended defense to amended particulars of counterclaim A41, A alpha 41 to A50.
Yeah. Yeah.
This is the markup. It's in markup, which is very helpful, and I'm thankful for my friend for being diligent. Sorry, I exaggerated. It's 4 pages, not 3. This was filed 14 days after the amended particulars. 243,000 divided by 14 makes 7.
Yeah.
They needed 14 Mondays for this. I say this, and I said before, it's not my habit to question colleagues' charges, because I would like to think that my colleagues are professional and would not try to overcharge or anything like that. Why I say this is that this is a very big number. 268,000, 60-something, 68,000 indeed. 243 for the amendment and 25 for the application itself. It's a lot of money. It's more than the money that they would that they were asked to pay to the court already. The first time we heard of it when there was another order of 110,000 against them. That's the very first time that we heard of it. As a means to delay payment of an order, if I may remind Your Honor, on the indemnity basis. I mean, the last thing that a party would want to do is show, quote unquote, disrespect to an order on the indemnity basis. And orders on the indemnity basis are not, the common staple. They're not issued every day. They are rather random, actually. And what was the defense to that? Let's make a counterclaim. We have an order in our favor. Let's make sure that it is big enough so that we don't have to pay the 110,000.
Mm-hmm.
I would not like to waste your. Obviously, I'm happy to discuss any point, but there is one last comment that I feel I should do.
What's that?
What is the purpose of the application for security of costs at the end of the day? What is it, in other words, what the court is required to look at? It is justice. I put to you that it is justice. If in the circumstances it is just to order a security for costs, then it should be ordered. And I would like to make reference to the precedent that my friend cited, which is the Al-Horafi case.
Mm-hmm.
Let me find the right passage so that
K1. What is the passage in the case?
I will, if you bear with me, I will locate it in a moment. Can you help me, Mr. Bull, with this? With the particular reference?
What are you looking
Yes.
for?
Yes. I found it. If you look at Paragraph K11.
Page K11.
Page K11 of the bundle.
Yeah. Yep, I've got it.
That's paragraph 48.
Yeah.
Such orders, therefore, have the purpose of protecting a defendant from the injustice that would be caused where, having successfully defeated the claim against him and having recovered an order for cause against the claimant, he was then left in the position of being unable to enforce from the injustice that would be caused. This is the purpose of an order for security for costs. In our case, we are, I submit that the injustice, if security for costs is not awarded, will be flagrant, with all due respect. We have a claimant turned defendant turned claimant who are in no position whatsoever to show that they have any assets, any business, anything whatsoever. They only comply when it suits them. They made a claim, and just for the record, and obviously you are not required, actually you are discouraged from looking into the merits of the case. This is what Rule 27 requires. But I'm very happy, and my friend on one hand points out to this, and on the other hand hurries to make submissions on the substance and the merits of TCD3, 5's claim. It has no merits at all. It is a hopeless claim, if not for any other reason, because it is pleaded as a common law concept in a civil law jurisdiction. Indemnity is not what my friend pleads to be. And in the UAE, as in every civil law jurisdiction, loss must be proven, actual loss must be proven. Even concepts like delayed damages in civil law jurisdictions are much less strict than in a common law, under how we understand them under common law. Their own asset, the only asset that they have offered evidence is their counterclaim, which, by the way, is now less than the claim. The CEO of 5 Group, 5, the claimant, we cannot really tell. Mr. Akiki, anyway, he made a witness statement as part of the production, and very rightfully, he's very proud of the importance of 5 Group. Very successful hotels, very successful developments. And they are. None of it for the litigant in this dispute. This cannot be by accident. They are ready to demonstrate how strong and robust 5 Group is. They are unable, reluctant. Burden of proof does not require. That's the argument. that 5 real estate, the exact name, 5 real estate development LLC, the litigant in TCD3 has at least a bank account, some balance in the bank account. To conclude, Your Honor, our application is under Rule 25. I think I omitted paragraphs 4 and 6 of 25-102. Quickly, very quickly.
Does 4 matter? And we're a long way after the claim form and the address. You have the address now?
We do. We assume we do. Well, we assume we do.
Right.
We assume it is the same address of the other 5 group entities. One last thing, because when preparing for this, you know, for the hearing, I asked myself, I mean, I thought, I tried to put myself in your and my friend's shoes, try to think what would be the question. I would ask myself the following question. Hang on, this is an application for security for costs. You ask for what? $1 million, something more than 1 million dirhams, 250,000 pounds sterling. As a defendant in TCD3, what have you done as a claimant in TCD9? You have a what you describe as an insolvent, untrustworthy, an opponent that has no money, and you have a much bigger claim. You have a 17 million dirhams and counting claim, which is many millions of pounds. Why are you so concerned about your security for costs in TCD3 and not your claim in TCD9? And the simple answer is because, unfortunately, right now, that's the only means available to us. As a claimant in TCD9, we don't have any. If we make an application for a freezing order, we might very well win it and do nothing, have nothing to do, and can do nothing about it. An attachment of assets. What assets? We have nothing. The only thing that we can do to limit the exposure right now is the security for cost application in TCD3. And the last resort is, at the end, assuming, and it's a big if, we win TCD9, then sue the parent entity of 5 real estate, whatever their name is, and claim and try to lift the corporate veil. That's the only option. So this application here, it is not only just and fair, it is the only available means to Reem to limit its exposure.
Yeah.
I respectfully submit that if this is not just, I am not sure what would be just at the end of the day.
Yeah. All right. That is the security for cost application. Do you need to say much about the practice direction number 5?
Very few. Again, my friend's defense is, I think it's paragraph, is it paragraph 5? Yes, it's paragraph 5 of the practice direction. It's, if you can find it at paragraph page M7, Mama, M7 of the bundle.
Yeah. Paragraph 5.
Yeah. Which makes reference to statement of costs. The only, again, well, the main, not the only. The only criticism from my friend is that practice direction number 5 makes reference to statement of costs, and we have produced bills of costs. Disregarding that, if there is any difference, the bills of costs are more detailed than the statement of costs.
Yeah.
I.e., therefore, allow my friend and the judge to have a more detailed understanding of what it is claimed. Notwithstanding that,
can you tell me
the registrar also sees it the same way.
Is there a technical meaning for statement of costs in the rules as opposed to bill of costs?
I don't think not in our view. It's interchangeable, and this is our this is how we see it. There are different forms, P38 and P40, if I'm not mistaken, P38/01 and P40/01 for statement of costs and bills of costs. In this particular instance, and for the purposes of the practice direction number 5, which again, what is the purpose of practice direction number 5? To afford a claimant which has been awarded, to afford a party that has been awarded costs, some comfort. 50% of the costs payable immediately, 50% upon detailed assessment. In this case, statement of costs are submitted prior to hearings, as both parties did for this hearing. The applications for which we ask this payment of 50% on account were determined on papers without any forewarning. If there were hearings, we would have submitted statement of costs. There was no forewarning or anything that it would be that there would not be a hearing. Neither party submitted statements, by the way. We're being criticized for exactly the same thing that they also did not. They did not submit statement of costs because there was no hearing. And we are here now with bills of costs, which offer much more information, are much more suitable for a detailed scrutiny of the claims, of the costs requested.
Where do I find your bills of costs?
Give me a second, please.
Is it in? Is attached to your witness statement?
Yes, it is attached to witness statements. Yes, they are bundle of exhibits. I assume it's F99 to F107. Yes.
Yeah.
No, that's Mr. Kumar's. Mine is F86 to F90. Apologies.
No, that's Mr.
F25 is the reference.
F25 is the one.
Yeah.
Thank you very much.
Okay. Yes. As you can see, if you look for example at page F28, I'm not sure what would be more detailed.
Yeah, I follow.
And you know very well, Your Honor, that a statement of costs, by the way, has much less information. And we were criticized by my friend because when we used statement of costs, we were criticized because the information was not enough. We filled in P38, what its name. And when we produce the detailed information, then we don't comply with practice direction number 5.
All right.
It can't be both. Something doesn't add up.
Okay. Well, I follow that.
As for the
So-
case progress monitoring, I think we can only confirm that it's in progress. There was, as I said, an agreed extension, and we are thankful for the acceptance of the consent of the consent order for a slight extension for the submission of expert reports. We are on track for trial as scheduled. And
So
this has been confirmed by both parties.
Do you want me to make any order on that form, or should we deal with that at the end in case there's any point?
Yes, let's do.
Yeah.
I suggest yes, Your Honor. Let's do it at the end. Can we have can I please ask, I assume it will be my friend's turn. Can I please ask for a 5 minutes break, convenience break?
Yes. Are you happy to have a 5-minute break?
Yes, certainly.
Yes. Well, we'll resume at 10:50 UK time, which is 1:50.
Thank you very much. Yes.
1:50 Dubai time.
Yeah. Thank you.
10 to the hour. Okay.
Yeah. 10
Thank you.
10 to the hour. Thank you.
Thank you.
Mr. Costello,
Yes.
it's your opportunity.
Thank you, my lord. Well, I will deal with the security application first. And first off, we don't accept that there is only one or the only defense offered by 5 is that the application was late, albeit that is one defense that is offered. The other attacks that we make on the defendant's application is that by virtue of the contents that has been alluded to within the skeleton argument and by Mr. Kumar, the position that 5 takes is that the court isn't or shouldn't be satisfied that there is reason to believe that 5 will be unable to pay the defendant's costs, as opposed to anything less than that. I'll develop that submission in due course. And as part of that, and I do focus on 25.102.2.
Yeah.
Primarily for the reason that my lord indicated earlier, which is I suggest 4 falls by the wayside. In fact, because we're quite advanced in the proceedings, and the issues covered off elsewhere. And in relation to 6, well, on the one hand, my learned friend says that there are no assets, so I query what the point he's making about the claimant taking steps in relation to his assets. But nonetheless, I suggest that the primary focus of my learned friend has been in relation to 105 to 102.2. And really his submissions go through that. So unless you need me to address you any further on 4 and 6, I'm going to focus on 102.2.
If you do that for the moment, if there's anything that arises under 6, I'll let you know.
Certainly, will do. In relation to taking it in turn, chronologically, because the application we say should have been made at the CMC, I think my learned friend has accepted that the wording is such that the application should be made at the CMC. And I accept, of course, what he says about the considerations of delay to the prejudice of the other party or the administration of justice, and also on harassment. But taking it in steps, the first question is, was it made at the CMC? No. Why was it not made at the CMC? My learned friend has gone through the chronology, which he has helpfully provided to us as well, which I thank him for. But looking at TCD, and we are obviously concerned with TCD 003 for the purpose of this application, that was filed and served on the 23rd of September 2021, as my learned friend has said. He
So
then
what was
goes on
that date again?
23rd September 2021.
Yeah.
And then he has said today that the first time it was established and concluded that the claimant could not satisfy any cost orders was at the end of October. And with the greatest of respect to my learned friend, that was the date that the defendant filed its reply to the defense. It is not, I suggest, the date that can be said is when the defendant knew, as they say, not that I'd make any admission on that, that the claimant would not satisfy cost orders, because that would have been actually taking a reasonable view end of September, beginning of October, because by then they would have had the. Oh, sorry, I'm being advised that my own friend has left the call.
Oh. I don't think I did anything to.
No, I don't think your lordship does anything. But judging by the way IT has been today, it's probably one of those things that's just happened.
I don't think I have the power.
No, he knows he's disconnected. He's trying to rejoin.
Right. Thank you.
I can assure my own friend it wasn't me who removed him from the hearing.
We better wait to get him
Yes.
back.
Yes. Just to let your lordship know, I can see Mr. Carvelis, but he's frozen. So, if Mr. Carvelis can hear me, then I hope he can take note of that.
Mr. Carvelis, are you there? You're frozen.
Hi, Mr. Carvelis, can you please sign out and log back in again and try again? Check your connection, please.
I don't know whether you heard that. Mr. Carvelis, are you there?
I'm here. I cannot see you, but I'm here. Yes, Your Honor.
We can see you. Are you happy to go ahead like that, or would you prefer to log out?
Please. Yes, please. No. Yes, Your Honor. Thank you. No, please go ahead. I mean, it's not fair for my colleague. I'm not sure what happened. It was disconnected, but I can hear you now. Thank you.
Thank you.
My lord, I'll commence again on just this point of the submission, on this point that I was making. So just for the benefit of my learned friend, I was making the point that the claimant filed its particulars of claim in the TCD 003 case on the 23rd of September 2021. My learned friend said today that it was first established and concluded at the end of October that the claimant, that the defendant knew that the claimant would not satisfy any cost orders if so ordered. And the submission I was making is that, with respect, that's not a fair assessment. On a reasonable view, that conclusion, if it's a conclusion which we don't admit, but of course my learned friend takes, that would have been either at the end of September or the beginning of October, because the particulars of claim were filed at the end of September, and presumably at that point, upon review of the particulars of claim, my learned friend, his staff, even the defendant, doesn't matter which one, would have taken the view that it currently takes. So that being the case.
I thought, I may be wrong, I thought Mr. Carvelis relied upon your reply to the defense. And
yes.
I now can't find the reply in the
Oh, in the
on
chronology, it's at
Yeah, not the chronology, but in the bundle itself.
oh,
I thought I saw it earlier.
my lord, just bears with me. Just I can't find the reply in the bundle, but it was certainly in the chronology that my learned friend relied on.
Yes, and the reply was served in
31st of October 2021. Which is why I presume he referred to the end of October.
yeah. Right.
But in any event, as we say, it would have been, it would, on a reasonable view, it would have been earlier on. Now, of course, I accept that the defendant has time to file its defense or reply to defense, but in terms of making an application for security for costs, it would have been it would have had the view earlier on. The defendant could, and we say should have, made the application either at the same time as the reply or sooner, but certainly no later than the 31st of October.
We're talking, are we not, of a delay on a period from the CMC on the 17th of November to the application for security for costs made on the 30th of November. That's 13 days.
That's 13 days, yes. 13.
Yeah, and that's really what the argument's about, is it?
That's on this point, yes. But as we submit, had the matter been well, let me put it this way. The essence of the submission is this: that the claimant should obviously know at an early stage whether such an application is going to be made. That has to be the starting point, because it should know before, for example, incurring costs in disclosure, witness statements, experts, etc., the lay of the land, certainly in respect of security for costs. I accept, and my learned friend is right, that the cases were consolidated on the 17th of November. That is right. But that doesn't still answer why the security for costs application couldn't have been made before. Sorry, my lord, I'm pausing again because I've seen my learned friend has left the hearing.
Yes, if you pause a moment. Mr. Carvelis, are you there? We'll wait. I'm sure the Shara, are you there? Or Maita?
Yes.
Can someone email Mr. Carvelis and
Yes.
get him to rejoin us?
Certainly.
Thank you.
I think my learned friend is back, but if he could indicate if he has returned.
I can't see him.
Yes, I'm back. Can you see me and hear me now, Your Honor?
I can't. I can see you now and hear you. Yes, thank you.
Yes. Sorry, it seems that something happened with my laptop and I had to switch to the iPad.
Right. We'll keep an eye on the screen and make sure you're still here. Yes. Mr. Costa.
Yes. Before I continue, I just want to make sure Mr. Carvelis is, okay. Just want to make sure Mr. Carvelis was in a comfortable position. Yes, I was saying, I was submitting that the application should and could have been made, if not before the 31st of October, but certainly at the same time. Yes, the cases were consolidated. That's absolutely right. But the application could still have been made. That doesn't follow. It doesn't follow that just because the cases were consolidated, the application couldn't have been made. I hear what my learned friend says about the congestion in terms of the timetable, but my learned friend is, if not himself, then I'm sure a colleague could have done it, could have made the application. I don't say any more than that, but the overall theme of our point is this is an application that rightly ought to have been made sooner. Now, the prejudice I was touching upon is in relation to, I'm repeating this again because for the benefit of my learned friend in case he wasn't here, but it is that a party should know before the proceedings have commenced the situation in relation to a security for costs application, because such an application could have the effect of stifling the claim. The problem we are in now is that that FIVE is knee deep in this litigation and is now just before the exchange of expert witness statements, going to wait for the outcome of my Lord's judgment. I'll come back and deal with delay in a minute in terms of the hearing in this application. But even if it were sooner, it still would have been past production, and it would have been in the stages of, in terms of realistically when a hearing could have been heard, at the time when witness statements were being prepared. So it would have still, regardless of when the application would have been heard, still at a time when the parties both were very invested and quite far along in their preparations for trial.
Just so I understand your point, are you saying that the application should be made, not only the application should be made before the CMC, but it should be heard before the CMC? What
I'm saying, yes. So let me make it clearer. Certainly, the application should not be made later than the CMC, but
sorry, just interrupt. If that's the relevant test, then you're talking about 17 days, 13 days rather. It's difficult to see how prejudice could be caused by a delay of 13 days, unless I'm missing something.
Well, it's because of the consequences in terms of witness statements being served in support of the application. Obviously, will need to be considered following on. So let me break it down. When the application is made, of course, there'll be reply witness statements, and then there would be responsive witness statements from the other side, and then scheduling for a hearing. In this case, what happened is, and as the defendant accepted, there was some material missing from their application, which the claimant identified, necessitating a further application by those who were instructing my learned friend, and which caused the delay of a few weeks, I think, or maybe a couple of weeks at best, because there were more submissions made, and there was some time afforded to my learned friend to make further responsive submissions. So the point is, yes, it is 13 days in terms of the application being made, but it all has a bearing as to when the application is finally resolved. And on that point, I wanted to make just deal with my learned friend's point about the timing of the hearing. I'm sure my learned friend will be very happy to know that it was the Persian New Year on the 20th of March, and actually I was not due to be working at all for a 2-week period up until the 29th. And in fact, there was no other colleague who could have dealt with the urgent application. And given the urgency of that application, I was strong-armed, one might put it, into appearing on the 21st. It is not the case that I think he's suggesting that we misled in any way. It was just the way, unfortunately, that application unfolded. And thereafter, of course, I went back on leave. So I understand why my learned friend makes the point he does, but I suggest that it's a little unfair to hold to suggest that this application could have been heard sooner. And the other point of making the application either at or before the CMC is that the CMC judge can take that into account in terms of timetabling. Understandably, the trial date may be pushed back slightly, but at least it would have been, the application would have been timetabled, and therefore avoid any delay or prejudice. So those are that's the essence of the point in relation to 25-107. Moving on in terms of the, of course, I should say, I'm not going to repeat all the points that I've made in my skeleton argument. So if it appears that I'm not repeating something in there, then that is why.
Yeah, no, I have that in mind.
So, I'm grateful. The test that needs to be used, in fact, comes from 25-101. That's the starting point is that the court may only make the order if it is satisfied, having regard to all of the circumstances of the case, that it is just, and I emphasize the word just, to make such an order. And in addition to that, one or more of the conditions apply. Now, obviously, my learned friend, as I've said, primarily relies on 25-1022, but that from what 25-101, where we go from there is, even if you take the view, which we don't accept, but even if you were to take the view that 1022 applies, it doesn't lead to an award of security for costs, because you would need to decide if it is just in the circumstances to make such order. So in that sense, it is two-staged, but overall, the test of whether it is just trumps all other conditions.
Mm-hmm.
And I don't think that's controversial.
No, that's what Mr. Calveris, the point he was making under reference to Al-Kharafi.
Yeah. Yes. And in fact, that was the as my own friend said earlier, that was the case that we had brought to the court's attention, of course, because it's a relevant case to consider.
Yeah.
But the point is that whilst such a discretion is afforded to the court in terms of the satisfaction of the conditions, that alone can't be sufficient. Looking at whether it's just and whether the condition of 1022 is made, I'll deal with them in the order of the condition first and then deal with whether it is just. As I said earlier, the court would need to be satisfied that there is reason to believe that the claimant will be unable to pay the defendant's costs and not may. I rely on a passage from Cook on costs, which my learned friend has helpfully included in the bundle, and I'll take you to it now, if my lord just bears with me for one moment, please.
N1 for N20.
Is N4.
N what?
So N
N6.
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 N for November, yeah.
Yeah. Okay, I've got it.
And can you see where it begins? Sub rule 2, the claimant is a company or other body.
Yeah.
And then under that rule, it says that, obviously reference to the civil procedure rules of England and Wales.
Yeah.
It covers the impecunious company, whether within the jurisdiction or not. It is important to note that there has to be reason to believe that the claimant will, and there is emphasis put on this, as opposed to may not be able to pay the defendant's costs. And what we submit is that this is a very high hurdle. I'm sure my learned friend will agree to that, because there needs to be certainty in that respect. Anything less than that, to coin a phrase from the criminal jurisdictions of England and Wales, anything less than that will not do.
Well,
So,
hang on. hang on a second. The word will is obviously more powerful than may.
Yes.
As introduced by there is reason to believe, not that it is proved.
No, of course.
There is reason to believe. In other words, it takes the will back to may, really.
Well, I was just,
Whatever Cook says.
sorry?
Whatever Cook says.
Well, in my submission, Cook is right, because yes, I accept that there has to be reason to believe, and in the in terms of the your judgment, you would need to be satisfied that there is reason to believe that the claimant will not be able to pay, because it doesn't reverse it back to may. I respectfully submit, because you could be satisfied, for example. Yes, for example, the defendant, you are right in saying that you do have reason to believe that they may not pay. But whether they will not pay, whether you have reason to believe they will not pay, I disagree with you. And the reason why I say that is because my own friend has gone to lengths to set out his position. But we say, when you look at it in the round, and this is sort of where it links in with the just exercise that I referred to earlier. Firstly, there is a high hurdle. We say there is a high hurdle. Secondly, the burden is on my learned friend to establish the fact. And thirdly, in the context of this case, where the defendant where the claimant has made payments which are not overall non-substantial payments. And this is the reference to the 1.9 million, the 125,000, and so on. Those are payments which have been made. My own friend is understandably, of course, from his perspective in serving his client's cause, seeking to undermine those payments. Payments were made. At least one may have been late. Even if they were all late, they were still paid, and they were paid because it was by court order. It wasn't the case that, for example, my client sought to shirk their responsibility. They paid by consent the 1.9 million, for example. They met the costs orders that they were meant to pay. The issue of the 110,000 is in a different category, arguably, which is as yet unpaid, because there is still a cost order that you had made against the defendant for the costs of an amendment and the amendment to the particulars of counterclaim, and therefore the amendment to the particulars of defence to the counterclaim. That was an amendment to a very substantial, I suggest, claim in this case, because the prolongation costs, and I'm sure you will see this in due course when it comes to the trial, the prolongation costs claim, which wasn't quantified by Reem, but by looking at all the material, which we indeed had to do so, it became clear that it was around 10 million at least, or 9.9 thereabouts. So it's a significant sum of money, for which there is again another challenge to the engineer's determination. You may recall that this case is primarily on the 009 case, relating to a challenge to the engineer's determination. So not an insignificant amount of work had to go into making or drafting an amended particulars of defence to counterclaim. 4 pages, 5 pages, 6 pages. It's not about that. It's about the quantity, I suggest. But I don't propose to get into the ins and outs of the costs. What I'm suggesting is that yes, the 110,000 is unpaid, but it's in a different kettle of it's in a different basket, if you like, because it's at the moment it's subject to I say a sensible solution, which may be a set-off. Whether it's partial or full may not ultimately matter. The parties are free to agree how much that set-off could be, but before we say the claimant embarks upon paying an amount of money to the defendant, it is only sensible and right for the parties to try and resolve the cost orders that are outstanding. So what the conclusion is, I suggest on this, is that the claimant is paying sums, has paid sums which have been outlined. There is an outstanding amount, but there's equally an outstanding cost order against the defendant, and therefore looking at the circumstances of the case, that should not sway your decision, I would suggest, against the claimant. In fact, in my respective submission, it should go to the claimant's favour that it has paid previous costs orders.
I think the point Mr. Calveris makes in his skeleton, and I think orally as well, is that to date, or at least recently, costs paid by your clients, the claimants, have in fact been funded by parent company or associate company of some sort. Just pausing there, is that right?
Frankly,
yes.
Oh, sorry.
No, I was asking you, Mr. Coshdale, is that correct as a matter of fact?
I can't actually assist the court on this, I'm afraid.
I mean,
because I don't have the information.
Mr. Coshdale, is it right that your client in fact has no assets of his own?
Again, what I've been advised is that the company is still solvent and it's due to have future projects. That's what I've been advised, and I'm afraid I can't assist my lordship any further than that.
Well, but let's assume, because in the absence of evidence, the balance sheet suggests nil as at a certain date in March, I think it was.
It was June 2018.
Okay, sorry, June 2018. There's no other accounts have been shown to contradict that. If it is the case that your clients are being funded, your client is being funded by associate parent or whatever company, the concern is, and one can see the logic to it, the concern, that it's one thing to keep on funding during the course of active litigation, but if your clients were to lose on their claim, and of course I've got no idea one way or the other whether they're going to lose.
Of course.
If they were to lose, there'll be no incentive for that same funder to provide the funds to pay the costs of the litigation. I think is clumsily put, Mr. Calveris' point.
I suggest eloquently put by my lordship, but answering my lord's point, we say that first of all, Five Real Estate Development, and I'll refer to them as Five Real Estate Development because, of course, Five is a Five holding. Yes, exactly. Five Real Estate Development is an LLC and it's still solvent. It's not an insolvent company. And my learned friend says it's an SPV. When an SPV serves its purpose, more often than not, they're dissolved. Of course, I accept there is an outstanding case issued by Five Real Estate and indeed against Five Real Estate Development. But the counterclaim, the claims are linked in the sense of the facts, but of course they're conjoined as well now in any event. So we submit that as far as we're aware and as far as we're concerned, yes, I understand the incentive is there to fund the litigation, but equally the incentive arguably could have been there to dissolve Five Real Estate at an earlier stage if there was no intention at all to keep it open. And at the moment,
that would have got rid of your claim there.
Understood, but the 009 claim had been dismissed before the TCD 003 claim had been made, so it would have been a defendant. And so there wouldn't have, there could have been dissolution in that stage. I'm not saying that it should or would have or could have done that, but what I'm suggesting is that it was open to Five Real Estate at that point to be dissolved. But it didn't, and instead it continued to engage in not only those proceedings, but also the present proceedings. So whilst I understand my learned friend's submission, I say in reality, this is a company which is paying its dues, and even after the conclusion of this case, I'm told and hence the point that was in my skeleton argument, that there are other projects that will need development. This is a big company, as my own friend has said. I'm sure Five will not be, whilst I don't have information to the contrary, but I'm sure Five's ambitions are not only limited to five Jumeirah and 5 Palm Jumeirah and 5 JVC, but as I'm told.
Sorry, Karen.
No. I was just going to say.
I was wondering where the evidence for that was.
Well, admittedly, it's something I've been told and confirmed today again, but I accept it's not necessarily in the material before you. But what I am suggesting is, based on what we know of Five, and of course, indeed, what my learned friend has said about the successes, which was detailed in Mr. Akiki's witness statement. There are going to be future projects in which case Five real estate development is needed and necessary, and in this sense, I suggest that this is why I started off with the will and may dichotomy.
Yeah.
That what my learned friend is saying is that he has reasons to believe that they may not pay, not that they will not pay, and that's why I suggest there is an important distinction to be made.
Right.
I'm just checking my notes, if you just forgive me for one moment.
Of course, yes.
I don't know if you need me to address you on I'm going to call it the Bhupinder Singh as the manager, but that falls under 6. So unless you...
So I'm not sure what you're...
I'm referring to my own friend's submission at paragraph... Sorry, yeah, moved forward the page. At paragraph 30, this is the 1026 argument.
Hang on a sec. Oh, yes, sorry. No, I'd focus on 102.2 rather than time on that.
Certainly, but in which case I won't say anything further on that then in those circumstances.
Right.
Just bear with me one moment. Yes, no. So then those were the submissions I wanted to make, in addition to the submissions that have already been made so far that I've already made in my skeleton. Just one point, if I may, on the investigation of the merits of the case. And of course, my own friend's right. There shouldn't be the court is discouraged, and it's strongly discouraged. That's the wording of 25.110.
Yeah.
Only in cases where it can be shown without detailed investigation of evidence or law that the claim is certain or almost certain to succeed or fail, will the merits be taken into consideration. The only point I want to make on this is that from looking at it from Raj Kumar made reference to the indemnity and this point in particular, the position that the claimant takes is that on first glance, and certainly as a prima facie case, we say that the indemnity forms part of an agreement freely entered into between the parties. That can't be denied, and it isn't denied. And in fact, my learned friend doesn't deny the existence of the indemnity. It is the enforceability of the indemnity which is really an issue between the parties.
I thought he denied in his pleading, denied the the whole of the case against him, including the contract with an indemnity clause in it, and he pleads without prejudice to that general denial. He says it's a stitch-up.
I
Unless I've misunderstood.
Sorry, I didn't hear the last bit.
Unless I've misunderstood his pleadings.
Maybe I need to double check it, but I understood that there was an admission that the indemnity was in the contract. I understand the other point my lord has made. I haven't got the pleadings to hand as yet, but I'll get it up.
Paragraph 2 of the defence,
Mm.
and then pleads thereafter to without prejudice to that contention.
Well, yeah, except yes, I understand.
Yeah.
I understood, but the point I make, which I think you can probably take note of now, is that of course the defendant relies upon clause 4.5 of the contract. I know it's a different clause, but it also, on the one hand, accepts the enforceability of certain other clauses, but on the other hand, denies the enforceability of 4.10. So yes, fair enough. There is this general paragraph, there is this general submission at paragraph 2, but in the context of this case, I suggest that we may be able to get through that relatively easily.
Yeah.
And when it comes to the indemnity, certainly on a prima facie case, the defendant is in a position where it needs to set out its position in a positive manner on the applicability and enforceability of the the indemnity provision. So in that sense, the merits can be considered, I say, because you don't need to go into a detailed investigation of evidence or law. I know that my learned friend may say to you, well, there is a lot of law that says that this provision is not enforceable, etc., etc. But as I say, the enforceability is a different point, which I concede has to be dealt with at trial. But certainly we say, in terms of considering it on a prima facie position, we say that there is enough there for you to consider. So unless there's anything in addition on those points I can assist you on, I wish to now move on to the amount of the security, which is being sought, but also specifically on the point of the breakdown of the costs, which is, and this is covered at paragraphs 36 onwards in my skeleton argument. I'm just pausing because I can see someone from those who instruct me is waiting to be admitted. Yeah, okay. I'm relying on the
paragraph what of your skeleton?
Paragraphs 36 to 39.
Yeah.
So this is dealing with the point of there being a lack of detailed breakdown. Now, you would have seen the Raj Kumar's witness statement 2, which I'm not going to rehearse again because obviously my lord would have read that in any event. But the point that we make here is that the Al-Khurafi case is a case where it's stated at paragraph 38 of my skeleton argument that in that case there was no sufficient evidence of the costs of the defendant so far incurred or likely to be incurred up to and including the trial. Applications for security for costs should always provide a detailed, and the emphasis is added on detailed, schedule showing the breakdown of their total figure for security. Were we otherwise minded to order security costs, we would be unable to quantify the required amount with any sufficient accuracy. And I say on that point alone, security for costs applications can be refused. Now, the detail, the breakdown that my learned friend relies upon is, if you're on a bit, my lord bears with me, it is at F76 onwards. So what we have there is attendance on opponent, etc., etc. What we're missing, I suggest respectfully, is the breakdown. And what I mean by that is not not just the
F-
hours.
F76, you say?
F76.
76 is the court form. Do you mean 78 possibly?
Sorry, yeah, sorry, my mistake. F78.
Yeah,
This is the statement of costs already incurred.
yes.
Those are the fee earners. I'm not, there are some points made about the fee earner by Raj Kumar, which again we adopt. But looking at the breakdown, we say this is not a detailed breakdown. Saying 11 hours and 6 minutes is not enough. 8 hours, 42 minutes is not enough. There needs to be a bit more detailed breakdown in the form perhaps of a bill of costs, which is far more detailed. Because the whole essence of a security for cost application is that the court is going to make a party pay in advance for costs already incurred and likely to be incurred. It's a significant payment of money that has to be forked up by the claimant.
It's not paying the other party, it's paying into court.
Well, yes, fair enough. But I hope the point isn't lost on my lord. But the point is that the paying party has to pay a significant amount of money to its detriment, obviously. But and that's why we say the justification in the Al Kharafi case was for a detailed schedule for that reason. And this, if we compare that, for example, to the statement of anticipated future costs, which is at page F82.
Yeah.
There is a bit more provided in the future costs in terms of the, for example, looking at F82 at the bottom, you'll see the notes.
Yeah.
But we say it's still not enough for the purposes of a security for costs application. Then he's saying that there will be substantial attendance on our client with great partner involvement. It is not enough. There is 150 hours provided, and without a breakdown. And again, the theme goes on. I know my learned friend is going to say, well, hold on a minute. You are seeking 286,000 by way of your correspondence in terms of the amendment to the particulars of defence. But we say, first of all, that amendment was in relation to an additional claim for a very significant sum of money, which had to be done in a 14-day period, work shared between multiple two, I can't remember exactly, but multiple fee earners, involving a lot of time reviewing material, taking instructions, and there will have to be a bit of cost potentially at some point in respect. But in terms of a security for costs application, which is what we're dealing with, there needs to be, I suggest, in line with the Al Kharafi case, a greater level of detail breakdown. So that's the submission I make. Again, as I say, Raj Kumar has made more submissions, which I'm not going to repeat, but those points would not be lost on my lord.
If an order was to be made, do you have a figure which you say reflects your various points?
I would suggest that and I think I made reference to this in my skeleton argument. I'm just looking for it now, but I made a reference to 20%. Oh, yeah, paragraph 32.
32?
Yes, 32 of my skeleton.
Hang on a second.
Yes, certainly.
Oh, I've got the wrong one, sorry. Hold on.
No.
Well, you've given 20% of any costs attributable to the defendant's defence of the claimant's claim.
That would be, yeah, that would be, I suggest, the starting point in terms of looking at how much of the court's time is going to be taken dealing with TCD 003. I don't accept, because I think my learned friend previously submitted, certainly in his witness statements, that it would be 40%, at least 40%, he said, attributable to the issue of the indemnity. I do accept that the factual matrix overlaps, but in terms of how the indemnity is sought and quantified, there is a material distinction. but not as much time, and I say far less time, is going to be attributable dealing with the issue of the indemnity, as opposed to the far more substantial matters that my learned friend wants to advance in terms of the prolongation costs and dealing with the engineer's determination, as well as dealing with the evidence on the prolongation costs, any substantiation of those damages, etc. That's going to take far more time than dealing with the indemnity, I respectfully submit. And thereafter, dealing with the quantum of the security, any adjustments that a reasonable deduction should be made for the points that I've suggested. So taking all of those factors into account in terms of assisting my lord as to a figure, I would suggest a figure in the region of 15% overall would probably be where we would pitch it. But that
15% of the figure.
Of whatever it is. Yeah, it was the figure that my learned friend had claimed. But
Well, you look at 35.4 of the defendant's skeleton.
yes, I was just looking for that now.
35.4.
There isn't a 35.4 on the skeleton.
Oh, sorry. 30. Oh, there is, okay.
There is, Your Honor. Yes.
It is twice.
Is 35.4?
Under the general heading quantum of security for costs at 35.
Oh, okay. Because it goes on to 35.1 on the
I don't know why that is.
the next page. So I'm sorry, I jumped ahead, assuming that was it. Anyway, I'm with your lordship now.
That I think I've now forgotten. I think that is a figure for
40%.
the amount of the claim. Is that the claim for security? Is that right? I thought there was a figure of 1440.
That was previously. My learned friend can correct me if I'm wrong. But that was originally sought in the draft orders and in the witness statement of my learned friend. But I think the defendant has revised its position since.
So if this is the amount of security that is sought by the defendant, what would your figures be?
I will need to do the maths, but
Where do I do? And we can do it if you tell me where to put your figures.
This was on the basis of 40%, unless I'm mistaken, by my learned friend. So I'll need to. What we would be saying is, if you were to order any costs,
legal fees anticipated is 44.5%, I think.
Well, we would be saying overall, you would take it should be a 15%.
Basically a third of that
Yes.
of that figure of
Yes.
860. Right. So that would knock off, for the sake of argument, 550. But you don't disagree with the other entries.
Well, except for save that for the legal fees incurred as well. We would say there would need to be as I say, because there would be a 15% overall. That's suggested to be 25%. We would say that would also need to be reduced accordingly as well.
I see. But the experts you're not complaining about.
Well, that's at 10%. So but except that, save that. I don't know if my learned friend's surely not going to be instructing experts in anticipation of any losses or any quantum in respect to the TCD 003 claim. That's because we are only dealing with the 003 claim. So in that respect, the experts' fees can all go, because one would assume that would be in respect to the 009 claim.
Why? I didn't understand, because his part of his defence to the 03 claim involves experts, is saying the delay was caused by main contractor and so on. Isn't that what the experts go to?
Yes, but that would be going to the 009 claim, because of course he suggests as part of the 009 claim that the main contractor was responsible and they're entitled to prolongation.
I thought they were also, though, using that same argument in opposition to the 03 claim.
Well, I hear what my lord says. I won't. Yeah.
Well, do worry. Okay. Anyway, so that's the thing to work on.
Yes.
Right.
That's all I need, I think, can be said on security. Unless my lord has any particular questions on security costs, I was going to deal with the payment of costs on account.
Yeah, payment of costs on account.
But the point here, as Madame Brennan said, that we make is there is a difference in terminology, and we say it's not interchangeable between bill of costs and statement of costs. Yes, bill of costs are more detailed. That is a fair point that my learned friend makes, but we say practice direction number 5 is quite clear. It refers to statement of costs, and in fact, there are other references within the rules. So looking at rules 38.34, the rule, just in advance of what my lord is about to read, there is, my friend is right when he says there is no definition of a statement of costs or the bill of costs. But the point I'm making here, just in advance to introduce the matter, is that there is a difference in use of terminology between statement of costs and bill of costs.
Right.
Which I don't think my learned friend would disagree with. And in fact, there are different forms in relation to both. I've also sought to rely on the, even in practice direction number 5 of 2014, in paragraph 5, there's a reference to statement costs, and in paragraphs 6 and 7, there are references to bill of costs. All of this goes to the point that the terms are not interchangeable. And one might ask, well, what's the point of this use of terminology? It is, as I submitted in paragraph 48, it is for the judge to assist the judge considering the application to determine on a summary assessment of the statement of costs whether or not 50% should be payable on account or not. And it's for that judge who had heard the application, considered the application, it'd be best placed.
Hang on, I thought this was not dealing with the summary assessment, because I thought the practice direction contemplated a case where there's been an award of costs to be assessed.
Yes, but that's the.
Therefore, the judge in the case isn't concerned with it.
No, so it's if the costs are going to be subject to detailed assessment, it will order 50%. But in order to order the 50%, he would have a view of the statement of costs that are being relied upon at that time. And the court would then have a discretion to see if it would order 50% or it would order otherwise. That's contained within paragraph 5. And what I'm suggesting is the judge, he or she would look at the statement of costs and in that sense summarily, and I mean it in that context only, have a look at the statement of costs and determine what would be the appropriate amount to order on account, not for a different judge in at least one instance, and far later, and not at that time, when having considered the application, decide whether 50% should be paid on account or not. What I'm saying is it shouldn't be automatic that simply that because there's a detailed assessment and because there's a bill of costs, although we say it should be a statement of costs, that 50% would be ordered. The mischief of this is for the judge determining the application, who knows what the issues were in that application and at that time is far more apprised and gripped with the application, decided 50% or nil is appropriate in the circumstances. I exaggerate in terms of nil, but I think it's the point. That's the point we make. That's why there's a distinction, and that's why we say at this stage it is not appropriate for 50% payment to be made. Otherwise, it would always be made, and I don't think that's the point of practice direction. Sorry, paragraph 5 of the practice direction.
Right.
Of course, I've made other points within the. I've developed that point in more detail in the skeleton argument, but But that's the point that we make in relation to the second part of this application. So unless I can assist my lord any further, those are the submissions that we make.
And what do you say about, there's nothing between you on the case?
Oh, sorry, yes. No, I think my learned friend, I have to admit, I didn't really hear what my learned friend said, but I think unless he said something to the contrary, we are agreed that the case has progressed. The expert witness statements are due on the 25th of April, if my memory serves me correctly. Other than that, the case has progressed as well as it could have in the circumstances.
And there's no further order that needs making at this stage.
No.
The only outstanding matters, I think, are the expert report on both sides.
That's right. There will be a PTR in May, which you don't need to make an order about, but just to let you, my lord, know what's happening. Other than after the experts, there'll be a PTR, and then we'll be getting ready for trial.
Yeah. Yes, thank you very much.
Thank you.
Mr. Carvelis, was there anything particular you wanted to come back on?
Very few points, Your Honor. I will start with the last part of the discussion. If I can take you to Rule 25.99, sorry, 25.99.
Yeah.
This is the rule in relation to security application for security for costs. This is the one directly relevant. You will see in link 3 a statement of costs already incurred, including the information required by RDC 38.35 and signed by the party or his legal representative.
Yeah.
And then if we go to 38.35.
38.35.
Yes.
Yeah.
The statement of costs should follow as closely as possible Form P38-01/01. So, Rule 25 requires a statement of cost, and Rule 30 and makes reference to Rule 38.35. Rule 38.35 prescribes that the statement should follow as closely as possible Form P38./01. I submit, and I don't think that my friend will disagree, that this is exactly the form that we submitted, the statement of costs. Is it, and this is what it is required in the context of an application for security for costs. Is it as detailed as bill of costs? Obviously, it is not. Did the legislator was aware of that when they set out these provisions? Yes, they were. What is the reason behind it? You pointed out yourself, Your Honor, because in an application for security for costs, payments are made into the court. So there is no risk for the party that is required to make the payment. It does not go to the other party, it goes into the court. It is a security. If they win, if this party wins, they will be reimbursed from the court. So we are in an, and I understand my friend's position, but we are in an awkward position where for my friend is trying to argue that what I see as clear language of the rule 25.99 in conjunction with 38.35 is not enough, and we should apply something higher, in his view.
I cannot see. I cannot see the reason how he can say that in the first place. In addition, and it is a little bit awkward, for a payment into court for the security for cost application, the other side, the claimant, it requires a detailed breakdown in the form of bills of cost, but for payments to Reem as part of the application under practice direction number 5, they do not want the detailed breakdown provided with the bills of cost. They want the summary, which they criticize as part for the security for cost application as not detailed enough. They want this to apply. I mean, it does not adapt, as I said earlier. These two.
Okay.
As for before I go to a little bit more general issues, as for the value, the famous 15%, as I understand, their argument is that if security for costs is to be awarded, then it should be limited to 15%. Assuming this is correct, the only thing I can say is that they value their claim very cheap. I'm not sure there is much more arguments to make here. They have made a claim which was originally 17 million. Now it is 13 million. And they value it that it takes a little bit of work for the defendant for him to defend against it. This is what they say. I wish it were the case. And to show the absurdity of the argument, let's see if experts will require. And let's see what is the claim. What is this famous claim of TCD3? First of all, it is not just the indemnity claim. My friend forgot to mention that there is another element to the claim in TCD3. They ask for as compensation loss suffered over and above the liquidated damages which they have deducted with the engineer's determination. Their argument is that the delayed damages do not reflect their actual loss. The law, UAE law, correct me if I'm wrong, but I think it's 268, paragraph 268 of the Civil Code, allows them, even where there is an agreement for liquidated damages, a party to claim any actual additional damage suffered. This is what they're arguing. Probably, obviously, they will have to prove it. I assume that they will do this by means of their quantum expert. Obviously, the Reem's quantum expert will have to defend against it. So this is one element. And the second element is the famous indemnity clause. They argue that the indemnity is done deal, it is in the bag. There is no way that they can lose it because they don't need to prove any fault or harm. All they need to show is that they suffered a loss. I will not go into the detail of whether this is the case or not, but I would assume that their quantum expert will produce as evidence something more than the letter of the parent company to the subsidiary that the subsidiary owes a few millions to the parent entity. Because again, they may not, as they argue, need to prove harm, to prove they don't have the burden of proof or they need to show that there was a breach. But still, quantification is another thing. Assuming that their expert will produce some evidence, this will be countered by the evidence of our quantum expert. Because if I'm honest, we doubt that they are in a position to offer any meaningful factual evidence, we have reduced so much the component of the experts to only 10%, less than what they asked. If we thought, to be precise, if we thought that they were in the position to offer any meaningful substantiation of what they call their claims, we would have requested not just 44% as in the case of legal arguments, but actually more than that as a component for of the quantum experts' work attributable to TCD3. We don't. We took a risk here that they are not able to produce any evidence. That's why we only ask that 10% of the fees of the quantum expert is allocated for the security for costs. Going now, unless you have, you would like to raise anything to the very last point that you discussed with my friend. The famous difference between statement of costs and bill of costs. Now we have, at least we have narrowed down our disagreement to the difference in use. If I understood correctly, and I stand to be corrected here, my friend's argument is that basically that practice direction cannot apply at all if the costs were ordered by means of an award on paper or an order on paper without a hearing. This is what my friend is practically saying, because he is saying that no other judge no other than the judge that looked at an application which resulted into an order which included an order to pay costs, no other judge is in the position to look at it and pay 50% and apply paragraph 5 of practice direction number 5. Respectfully, I find it very difficult to see any sense in this argument. Where is it in this paragraph 5 that only that judge that took control of the order can order 50% of the amount claimed? It's nowhere if one looks at the language. Then it comes to the quantum, which I will sound like a broken record now, but I will repeat what I just said earlier. Previously, for payment into court, we want bill of cost, which is more detailed, but for payment 50% to the other side, we want the less detailed form of setting out these costs. It does not really add up. Very quickly, Your Honor. My friend's point is, one of his starting points was that, hang on, it's not 31st of October that we knew in September. That's when we knew. This is what they said. We knew in September and not in October. Leaving aside the obvious that making an application without having at least pleadings completed would look would not look very efficient. The least that a defendant should do in this case is wait at least for the pleadings. And the pleadings, they're not much. The particulars of claim, particulars of defense, and reply to defense. It's not that it has to wait for many rounds of pleadings, second round, rejoinders, so on and so forth. But let's see at the pleadings itself. If I can take you quickly to A27. A27 is apologies, the A11. A11. The particulars of claim filed 23 September. Let's see what they say in the particulars of claim. In paragraph 1, they say now that the claimant was engaged by the owner. That's the first time we hear it.
Yeah.
And in paragraph 5, they say upon completion, the hotel would be managed by 5 hotel pursuant to hotel management contract, and so on and so forth. Let's see how we responded to this. Let's look then at the particulars of defense at paragraph 6, which is in A19, a few pages further down.
Yeah.
In respect to paragraph 5 of the particulars of claim, the defendant is unable to admit or deny these allegations, because it has no basis upon which it could know the commercial dealings. The defendant requires the claimant to prove this allegation and disclose the ownership of the hotel.
Yeah.
Now, admittedly, the reply to the defense is not part of the bundle. I put to you, and I stand to be corrected by my colleague, there is no response to paragraph 6, the defense, at all. There is a response. I'm looking at it on my screen. I am sure my friend can do the same. The reply to the defense skips in paragraph 11, addresses paragraph 5 of the defense, and then paragraph 12 addresses paragraphs 8b to 8f of the defense. Nothing in relation to 6.
Yeah.
Simple fact, until we saw the defense, we could, and we are still not entirely sure what is the situation between the claimant, 5 real estate, and their parent entities. And we only had any further information was during the disclosure exercise, the production exercise, which followed by a few months.
Yeah.
When we actually made the application for security for cost, it was not just the earliest we could. My concern was that we made it too early, actually. My concern at the time was that we should have perhaps wait for the production before we make the application for security for costs, so that we have more accurate information. It's the opposite, actually. We could not. We risked perhaps two more than we should by making this application as early as we did it. I'm afraid it is the quite opposite than my friend's position.
Yeah.
Very few additional comments. I appreciate my friend's position. He had to break, he had to interrupt his leave. I have been in his shoes. Unfortunately, this is the line of business that we chose to do. But with all due respect, the point remains. When it suited 5, a hearing could take place even at a time of extreme inconvenience for their counsel. When it is in relation to an application by Reem, the same flexibility is not afforded. The question is whether there is reason to believe that 5 will not be able or may not be able. The way, respectfully, the way I see it, whether it is will not be able or may not be able is not of importance in this particular case. It is abundantly clear. They have no assets. My friend was in a very difficult position. He was not even able, at least today, to offer something. They have nothing. And because there is a, I wouldn't say, I don't want to say that it is misleading, but it is not accurate. Any payments, and I will reiterate, any payments made by 5 today was not because they were forced, because it was their own interest, to serve their own interest. It is not out of respect to court orders. Many more payments would have been made if it was an issue, if they did respect court orders. Of the 2 million that they paid 1.9 so that to avoid a default judgment that would force them pay this amount of money to Reem. In order to pay it to the court, they added 150,000 on top for costs awarded. It is just, I'm afraid, as simple as that. We heard again today my friend that 5 real estate, the claimant here, they are very significant in 5 groups structure, and they have, they play a very important role. They are involved in various high-profile projects. I assume those mentioned by Mr. Akiki. Again, nothing but the word of my friend. It would be very simple to defeat the application. All they needed to show was a contract. Even a contract as bogus as the one that they did for the Jumeirah Village Hotel.
Mr. Cavadas, I don't think we need to get too oratorical at the moment.
I apologize, Your Honor. I get carried away. Nothing. Bank accounts, statements, something. Yeah. Nothing, anything. Last but not least, you yourself, Your Honor, awarded 110,000. It's not a big amount of money for this dispute. And for an organization as big as 5, as they present themselves, the least that one would expect is day after your order, the email that was sent 16 days after your offer, 17 days after your offer, your order. At least If not, straightforward payment, and then, by the way, a similar application, if we did not agree, for the 50% of the whatever they call, they consider as the costs for the amendment of the defense to counterclaim.
Yeah.
Not even this. An email at the 12 plus hour between lawyers, and my friend will not, I'm sure, disagree, that we have also made sent such emails on other occasions for the agreement on costs. And they have not been replied at all. So, if I'm honest, I can't see what is the point that my friend is trying to make. And one last point, and this is not so much relevant to the point, but as this professional advice, if you like, as a lawyer. Unenforceability or invalidity of the part does not mean necessarily unenforceability or invalidity of the whole. You may have a clause in a contract, 4.10, for example, which may be entirely unenforceable or void, by the way, and you can have other clauses, 4.9, 4.5, for example, that are perfectly enforceable and void. This is as a matter of principle. So I'm sure I don't think I can understand the argument. Of course, we dispute the application of 4.7 the way it is pleaded. This has nothing to do with whether 4.5 is also applicable or not. And as I said, this is not directly relevant to this application, but as a matter of principles of law. I rest, Your Honor.
Thank you very much.
My lord, there's only one point of clarification because my learned friend said something. It's not a reply, but it's just to clarify. The submission I made on the point about when the application for security should have been made, and as my learned friend said that, quite rightly, he said that the defence was on the 11th of October, I recall. Yeah, 11th of October, 2021. That's for my lord's reference. That's at page A26, which my lord can look at in your own time. But the point I wanted to make is that in the body of that defence, in particular paragraphs, for example, 3B.
Yeah, hang on.
The defendant, oh, sorry.
3B, yeah.
When one reads all of that, and then gets to the concluding paragraph 3B, Roman numeral 5.
Yeah.
It's clear that the defendant's position is that the claimant would be committing an exorbitant loss as a result of the way the case is pleaded. Now, this is a matter for the merits in whether or not that's true or not. But what the point I'm making is the reason why we say certainly end of September, early October is because of the way the defendant pleaded its case in terms of whether or not, and this will link to the security for costs application, whether or not the claimant has assets, is able to pay security, because in the context of what my learned friend submits, there are losses owed to the owner. And so that being the context and this being the starting point, the reason why we say the defendant would have known late September, October, and I stress the word would have known, as opposed to would have made the application, but would have known at that time is because of the way they pleaded defense. I agree with my learned friend. He's not going to get any dispute from me. The application could not really be made before the 31st of October, and I tried to make that clear, but I'm just clarifying. That's all I do, is to clarify why that submission was made, and in the context of why we said no later than the CMC, but certainly by 31st of October.
Yes, I see. Yeah.
Anyway, that was the only clarification I wanted to make. So that's the only point I had to say. Thank you.
Thank you very much. Yes. Well, I've reached a decision in this case. I think the best thing is if I give my decision now, and an order will be drawn up to reflect it. If either party wants more detailed reasons than the reasons I'm going to give, they can ask the court, and I will provide them as soon as possible. But I think the substance of my reasoning will appear from what I say. So far as concerns the security for costs application, I am satisfied that the claimant, I'm going to use the technical terms claimant and defendant, claimant to mean 5 and defendant to mean Reem. I'm satisfied that the claimant has no assets of its own, and there's no evidence being put forward to suggest or to flesh out any assertion that it has contracts enabling it to carry on business in a substantial way. It is not suggested, there's no positive suggestion being put forward on behalf of the claimant that it has met its own obligations under costs orders to date. It may well be that it has been supported in this respect by a parent or associate company. And that is the inference I draw in the absence of any other evidence. There's no guarantee in those circumstances that a parent or associate company will continue to support the claimant in paying the defendant's costs of defending the claim successfully if that is what happens. I have to assume for present purposes that the security for costs is intended to meet a situation where the defendant is successful in its defense to the claim, and that there will be a costs order against the claimant in respect of that claim. Whether that happens or not, of course, is a different matter, but that's the assumption I have to make for the purpose of this exercise. On that basis, it seems to me that there is clearly reason to believe, within the terms of Rule 25(102), subparagraph 2, that the claimant is a company, and there is reason to believe that it will be unable to pay the defendant's costs if ordered to do so. For this purpose, although I recognize the force of the point made by Mr. Kostel, that the word is will rather than may, in the circumstances I've just outlined, it doesn't make any substantial difference. There is reason to believe that the claimant will be unable to pay the defendant's costs if ordered to do so. I've considered the terms of Rule 25(107), which stipulates that first applications for security for costs should not be made later than the case management conference, and in any event, any application should not be left until close to the trial date. It then goes on to focus on prejudice to the other party and to the administration of justice. In the present case, the application for security was made on the 30th November 2021, the CMC having taken place on the 17th November, 13 days earlier. That is a very short time. More importantly, in the present case, there was a procedural or there were exceptional procedural steps taking place. The CMC of the 17th November was designed as a CMC for the existing case number 9. I'll call that number 9. It's the first of the two cases. And it was only at the CMC that the case number 3 was brought in and consolidated with number 9. There was, as Mr. Corvelis has pointed out, a lot of activity going on in respect of both case number 9 and case number 3 at the time. And it can be readily understood, in my opinion, why it was not thought that the consolidation of the two claims at the CMC in November 2021 should immediately bring into play Rule 25-107. But in any event, the delay was only some 13 days from the CMC before the application number 11 for security for costs was issued, and I'm not persuaded that that caused any that delay, if it can be called that, caused any prejudice either to the claimant or to the administration of justice. So in those circumstances, I do not regard that rule as a bar to the ordering of security for costs. As regards quantum, it seems to me that the starting point should be the figure set out in paragraph 35.4 of Mr. Corvelis' skeleton argument, not the figure in the application of 1 point, which is higher than that. The figure claimed is 1,210,822.09 dirhams. There are many detailed issues, on many of which it may well be, if there is an order for costs against the claimant, then maybe many of their points will be seen to have some force. At this stage, all I can do is choose an appropriate figure for security for costs, and I bear in mind, of course, that any amount ordered will not be paid to the defendant, but will be paid into court, and therefore will not be lost to the claimant in the event he is successful. In those circumstances, it is invidious to expect a judge to, except where the points are absolutely obvious, to expect a judge to conduct a detailed assessment of future costs. It seems to me that the appropriate course is to take the figure claimed by the defendant in that paragraph and make an order, since it is an estimate of future costs. I would round it down to the nearest 1,000 and award a figure for security for costs of 1,210,000 dirhams. That will be the figure that will go into the order of which I've been provided with a draft, and that will be payable within 14 days into court. So far as concerns the other aspect of this application, just give me a second, which is an application under Practice Direction number 5 of 2014. This application is made on the basis that there have been orders for costs made against the claimant. The costs to be assessed. Paragraph 5 of the Practice Direction provides that where the court has ordered a party to pay costs subject to detailed assessment, unless agreed, it'll order 50% of the amount claimed in the statement of costs to be paid on account before the costs are assessed, unless the court sees fit to order otherwise. There are two substantial points taken here. The first is the fact that paragraph 5, which I've just read, talks about the amount claimed in the statement of costs, and Mr. Coshdell, for the claimant, just draws a distinction between that and the bill of costs, which has been submitted in support of the application. It seems to me that it would be peculiar indeed if the statement of costs, which is a less detailed document, was to be a requirement of paragraph 5, and that a more detailed bill of costs would not suffice. There can be no logic or common sense behind construing the paragraph in this way. It seems to me for these purposes, the statement of costs must include a bill of costs insofar as there is any technical difference between the two. The second point made by Mr. Coshdell was that this rule, this provision, contemplated the judge hearing the application and making the costs order subject to detailed assessment unless agreed, would be the same judge as exercise the powers under paragraph 5. But as Mr. Carvelis pointed out, if that is right, that would mean that there could never be an order of this sort where the judge, where the court dealt with the application on paper. There would simply not be the opportunity for this order, or else it would be automatic. Clearly, this contemplates the possibility that orders for costs are made on a paper disposal of the application, and that the party can come to court later seeking an order in terms of paragraph 5 for payment of 50% of its of the amount claimed in the statement of costs or the bill of costs. So it seems to me that paragraph 5 applies in this case, and the amount claimed, there's no challenge to the amount claimed of 96,617.25 dirhams. And that is the figure, I think, set out in the draft order, for which I will give judgment. I'll just check the draft order. Yes, 96,617.25 as set out in paragraph 2 of the draft order. So that is my decision on the two parts of the defendant's application number 11. The only other matter to mention, and there's no need for any order in respect of it, is that both parties have submitted case management, case monitoring documents showing that they are on progress towards the trial, with the only outstanding matters on both sides being the service of the expert reports, which is not seen to be likely to cause a problem. So no order need be made about that. Any difficulties can be picked up later if necessary. The outstanding matter is the costs of the defendant's application. The defendant claims the costs of the application. Mr. Kosh, I imagine you would have no resistance to an order that the claimant pay the defendant's costs.
I can't. So
Yeah, I don't think you can. I will give you the opportunity of being inventive.
no.
No.
No,
Well,
thank you.
Thank you both very much for your help. I'm sorry we had technical
So,
mishaps.
My
Made
lord,
us run.
my lord, I'm
Yes.
terribly sorry. Sorry, maybe I misunderstood. No issue on the principle. Can I just make submissions on the quantum very quickly?
Yes, of
On
course.
the admittedly, and I say the context, I think just so for others who are listening who can hear, we claimed 167,500. That, and in the context, my learned friend claims 196,241. So we make the obvious point that, of course, I accept my learned friend had a bit more to do because, of course, they had the primary witness statement and the reply witness statement. I accept all of that. The only matter I would say is that there can still be some factoring in that overall we still had to review the entirety of the documents and the bundle, etc. And of course we did it in less time, and therefore we suggest that there can be some deduction made in respect of the defendant's costs. As I say, I preface that with the acceptance and acknowledgement that my learned friend had a bit more. My learned friend and his colleagues had a bit more to do than us because they started the application, but the context is still nonetheless that we still, overall, there can still be a deduction in the amount of time that it took place. The second point I'm making, this is the last one, I'm not entirely clear what the expenses or disbursements are that my learned friend claims. So in the absence of any clarity on that, I'll suggest that can be removed.
Yes, well, I'll ask Mr. Carvelis and then let you come back on that.
Thank you.
The disbursements.
The filing fee, Your Honor.
That's it.
Yeah, it's the filing fee. And I agree with my colleague that we are at 90% close. The difference is that we also prepare the bundle. So we did have some additional work to do. And may I take this opportunity? Reem would like to apply now for payment of 50% on account pursuant to practice direction, paragraph 5 of practice direction 5.
You're wanting the costs to be assessed, if not agreed, rather than me to fix the costs.
Unless you fix the costs. I'm not sure what you propose to do. If you fix the costs, we'll be happy with I'm not sure I understood what you said at the beginning, so I may have stepped the gun here.
Well, are you asking me to fix the costs?
Yes.
To make an immediate assessment and then proceed? Right, Mr. Costello, perhaps I should have clarified that at the beginning. I imagine that you would have wanted me to make an immediate assessment of your costs if you had been successful.
Well, for the coming to equity with clean hands, frankly, yes, we would have sought an immediate assessment summarily as well. So,
well, you've been told that the disbursement is the court filing fee.
I can't say anything against that.
Very well. It seems to me that you've very fairly acknowledged that. Well, first of all, the figures are relatively close. You've acknowledged that the defendant had a little bit more to do. Because it's his application, and as pointed out by Mr. Carvelis, they prepared the bundles as well. So I think in those circumstances, I can see no basis for deducting from the claimant's figure of 196,241. Is that right? So I'll award the claimant. I'll award the defendant the cost of the application in the sum of 196,241 dirhams.
And my lord, just to clarify, all payments, because I think you said 14 days for the security.
Yes, that should be 14 days for the other as well.
The 14 days for all payments?
Yes. Unless you want to make any particular application about that.
Well, I don't have instructions, so I can't.
It's always open to you later to make an application.
Exactly. I'll need to take instructions perhaps, but yeah.
Yes. Well, thank you both very much. And as I was beginning to say, I apologize for the glitches at my end, at least. This made us start late and therefore finish late. So with that, that concludes the hearing. Thank you very much.
Thank you, my lord.
Thank you. I apologize for the glitches on my end, Your Honor.